Ms. Okoye, please deliver your argument.
Good morning, Vice Chair Lada. Good morning, Ms. Higgins. Thank you for the opportunity granted to the Blue Heron Landowners Group, or BHLG, to participate in this proceeding and to present to you their final argument on matters that are of concern to them. The submissions that I make today are further to the BHLG's pre-filed written evidence and oral testimonies of their witnesses. The position of the BHLG on any point not addressed in this argument remains as set out in their pre-filed evidence and oral testimonies. I'd like to acknowledge the contribution of my colleague Chinedu Kema to portions of this argument, especially on the areas he covered in cross of Grand Solar's witness panel. The BHLG is comprised of landowners and residents who own or occupy lands in close proximity to the project. The BHLG are concerned about the adverse impacts of the proposed project and are opposed to the potential approval and development of the project as has been applied for by Grand Solar. The members of the BHLG were listed in Exhibit 96. Requested disposition. The BHLG submits that this project is not in the public interest and should not be approved. Although the BHLG had made an alternate disposition request in its submissions, in its group submissions, having heard the oral testimonies of Grand Solar's witnesses, the submissions of Grand Solar, the BHLG submits that the first disposition should be a complete denial of this project and sending Grand Solar back to the drawing board. However, we know we don't have the authority. We are not the deciders of this project, and you still have the discretion to decide the project. If you do decide to approve it, we submit that the Commission should consider and adopt the recommendations of the BHLG's experts and any other conditions proposed by the BHLG during the public hearing and in this argument as conditions of approval. The BHLG raised various concerns about this project, which were detailed in their group submissions and the detailed submissions, both written and oral, of the BHLG members. While I will not go into all the details of the concerns raised, I will raise the key concerns with a view to providing sufficient information that will assist the Commission in deciding Grand Solar's application. Going first to the first topic, the project siting on productive agricultural land and reclassification of the project lands. A key issue in this proceeding is whether the project lands contain Class 2 lands within its footprint, such that an agricultural impact assessment should have been completed and submitted as part of the application. Related to this issue are the following sub-issues. First one is whether the reclassification of the lands through soil survey is appropriate and sufficient to warrant a departure from the clear provisions of the interim information requirements, which I'll be referring to as IIR. Secondly, the interpretation of the word any in paragraph 4 of the interim of the IIR, and whether the use of the word any in the IIR triggers the submission of an agricultural impact assessment. The third related issue is whether the project lands are high quality agricultural lands as defined in the Electric Energy Land Use and Visual Assessment Regulation, which I'll be calling ELUVA or regulation, and whether the Commission can use its discretion to order an agricultural impacts assessment, even though Section 4 of the ELUVA limits the requirement to agricultural impacts assessment to wind and solar energy projects located on privately owned high-quality agricultural lands defined as being Class 1 or 2 lands, or 3 lands in certain municipalities. And the last issue is, the last sub-issue is whether the siting of this project on highly productive agricultural lands is compliant with municipal laws. I will now turn to discuss the issues. So, do the project lands contain Class 2 lands within its footprint? The BHLG submits that the project lands contain Class 2 lands within its footprint. as is evident through the review of AgriSeed as reported by Montrose. Exhibit 7, PDF 95, Table E, clearly states that 83% or 359.8 hectares out of 431.2 hectares of the project land are classified as Class 2 based on AgriSeed. The soil survey completed by Montrose also showed the presence of LSR Class 2 soils. Montrose reported the results of the soil survey in Table F of Exhibit 7. Table F of Exhibit 7, PDF 96, shows that HND soil series with slope gradients of 2 to 3 or less than 5% slope occupy 70% of the project area. During cross, Miss survey confirmed that HND soil series with slopes of up to 5% contain Class 2 soils. It is clear from Tables F of Exhibit 7, PDF 96, that 70% of the project land had LSR Class 2. Grand Solar's position that there are no Class 2 lands on the project lands is simply not supported by their written and oral evidence. Even the soil survey results using SIL 2 standards indicates the presence of LSR Class 2 lands in the project lands. In Exhibit 133 PDF 13, Montrose stated that site-specific calculations completed showed that the project lands contain locations of Class 2 soils distributed across the terrestrial study area, or TSA. At page 31 of the transcript, Ms. Survey agreed that 4 of the sampled HND soil series sites listed in Exhibit 159 were Class 2 lands. It's quite interesting this morning. You heard my friend mention that there are only 2 sample points. That's not the evidence of Ms. Survey. At page 33, lines 18 to 19, Ms. Survey agreed that even within the HND soils that they have mapped as Class 3 or 4, there are Class 2 soils therein. However, Ms. Survey argues that the soils cannot, the Class 2 soils cannot be distinguished either by visual inspection or by a review of vegetation. If the soil classes cannot be readily distinguished, as Ms. Survey claims, how then did Montrose arrive at those soils being Class 3 or 4 soils? This highlights the gaps or unknowns in the soil surveys and the reclassification completed by Montrose. As Dr. Whitson explained on transcript pages 229 to 230, the extent of Class 2 lands in the project lands can be delineated. Dr. Whitson and Ms. Nolan also noted in their report that the soil series documented by Grand Solar for the local study area largely matched those displayed in AgriSeed, although the degree of LSRS limitations associated with these differed. And I refer you to Exhibit 103, PDF 2. Further, in the undertaking response provided by Dr. Whitson following his review of the area of soil map units in the terrestrial study area provided by Montrose, Dr. Whitson stated that the probable extent of Class 2 soil ranges of Class 2 soil ranges from 10% to 15% of the TSA. Now, going on to the second sub-issue. Is the reclassification of the project lands by Montrose appropriate or warranted? The BHLG submits that the reclassification of the project lands through soil surveys was neither appropriate nor warranted. The IIR applicable to Grand Solar's application was stated in Exhibit 1, PDF 34 to 35. Paragraph 1 of the IRR on agricultural land requires the use of a current version of AgriSeed to describe the agricultural capability of soils intersecting the project footprint as provided in the spring seeded small grains attribute of the land suitability rating LSRS table. Based on the clear wording of paragraph 1 of the IIR, the applicable tool required to determine the LSRS class of the project lands is AgriSeed. There's no provision in the version of Rule 7 and the IRR that requires Grand Solar to conduct an independent soil survey to reclassify the lands. The review of accuracy demonstrates that the project lands are 83% Class 2 lands. That determination has satisfied the requirement of paragraph 1 of the IRR, and frankly, the analysis should have stopped there. In the Dulce decision 28723-D01-2024, the Commission stated in paragraph 22 of the decision that, and I quote, one indication of the value of the land for agricultural purposes is its ranking in land classification tools such as the Land Suitability Rating System, LSRS. While noting at paragraph 24 of the end of quote, while noting at paragraph 24 of the decision that the LSRS is represented at a scale of 1:100,000, the Commission stated, and I quote, at this scale, the Commission expects that the LSRS classification of the project will not be perfect, but will provide an adequate description of the agricultural suitability of the project for the purposes of assessing Dulce's application. The Commission at paragraph 24 of Westlock Solar Project Decision 28587-D01-2024 endorsed the use of AgriSeed and the LSRS classification within AgriSeed in determining the agricultural capability of soils intersecting the project footprint. The BHLG notes that the Commission's findings in Dulce and Westlock decisions are appropriate and applicable to this proceeding. The Commission ought to uphold and apply the provision of paragraph 1 of the IIR and accept the information from AgriSeed that the project lands are mostly Class 2 lands. If the Commission decides not to uphold the requirement to use AgriSeed to determine the LSRS classification of the lands as stated in paragraph 1 of the IIR, the BHLG submits that Grand Solar soil survey data also demonstrates that there are Class 2 lands within the footprint of the project lands, which is consistent with the AgriSeed information that there are Class 2 to 5 lands on the project lands. Dr. Whitson underscored this in his testimony at page 228 of the transcript, where he said that Ms. Nolan, Dr. Whitson, and Grand Solar agree that Class 2 lands exist in the project area. Going now to the next sub-issue, the applicable interpretation of the word any in paragraph 4 of the IIR. Paragraph 4 of the IIR requires the submission of an agricultural impact assessment if, and I quote, any LSRS Class 1 or Class 2 lands is reported within the project footprint, end of quote. As explored in Cross at page 36 of the transcripts, the ordinary meaning of the word any does not require a measurable or identifiable quantity. It could be one or some of an undetermined number or amount. In taking this position, the BHLG is guided by the modern approach to statutory interpretation, which has been endorsed by the courts in numerous cases. The Supreme Court of Canada in TELUS Communications, Inc. versus Federation of Canada Municipalities, it's a 2025 decision, stated that, and I quote, the meaning of a statutory provision is determined by reference to its text, context, and purpose. Statutory interpretation is centered on the intent of the legislature at the time of the enactment, and courts are bound to give effect to that intent, end of quote. While the IRR is not a statutory document in the sense that it was not made by the legislature, it is a regulatory document which was created by the Commission under the powers conferred on it by the legislature pursuant to the Alberta Utilities Commissions Act or AUC Act. Section 76(1) of the AUC Act gives the Commission the discretion to make rules governing any matter or persons within its jurisdiction, including, and I quote, the procedures and processes applicable to locating, building, constructing, and operating facilities or infrastructure over which the Commission has jurisdiction, end of quote. The BHLG submits that when considered within the context of a statutory document or a regulatory document, statutory document, the word any has generally been interpreted broadly. For this proposition, the BHLG relies on the Supreme Court of Canada's case of M&D Farm Limited and Manitoba Agricultural Credit Corp. Specifically, paragraphs 45 and 46 of that decision, the Supreme Court of Canada interpreted the words any act in section 8, subsection 4 of the Family Farm Protection Act of Manitoba to mean a leave application. In the Ontario Superior Court of Justice case of 936464 Ontario Ltd versus Mongo Bear Ltd, a 2003 decision, particularly paragraphs 25 and 26 of that decision, the court remarked that, and I quote, the words, in quote, any action could not be more broadly written, end of quote. The BHLG submits that this is the case with paragraph 4 of the IIR, which is also broadly written. As stated earlier, an ordinary meaning of the word any does not suggest any measurable, quantifiable, dominant, or significant quantity of Class 2 lands for an agricultural impact assessment to be required. If a measurable, quantifiable, dominant, or significant quantity of a particular class of land was required as a precondition to trigger the requirement of an AIA, the drafters of the IIR would have easily included that condition. However, none was included. I would suggest that the drafters of the IIRs were cognizant that within a proposed site for a project, that there could be different LSR classes, soil classification, hence the use of the word any reported within the footprint, and that any reported within the footprint should trigger an AIA. The BHLG also submits that the broad language of paragraph 4 of the IIR, by the use of the word any in specifying when an AIA, which is agricultural impact assessment, I don't think I made that definition, sorry. I'll say it again. The BHLG also submits that the broad language of paragraph 4 of the IIR, by the use of the word any in specifying when an AIA is to be submitted, aligns with the conservationist approach in agriculture first policy and the ELUVA, or the regulation. By ensuring that an AIA is submitted by proponents when a Class 1 or Class 2 or Class 3 land as applicable is found within a project footprint, the Commission is provided with information required for it to evaluate the best use of agricultural lands proposed for the renewable development. With respect, limiting the word any to a measurable, quantifiable, dominant, or significant quantity of Class 1, 2, or 3 lands as applicable prior to requiring the submission of an AIA will run contrary to the agriculture first approach and the conservationist principle that it endorses. Further, the BHLG submits that adding any quantification to the meaning of the word is contrary to the express wording and the ordinary meaning of the word any as used in paragraph 4 of the IIR. It is also contrary to the regulatory intent of the ELUVA section 4.1 precisely, that prescribed the completion of agricultural impact assessment on high quality agricultural land. High quality agricultural land is defined in section 1F of ELUVA as, and I quote, land rated under the Land Suitability Rating System, LSRS, as 1, Class 1 or Class 2 land, or 2 Class 3 land that is situated within a municipality listed in Schedule 1. End of quote. Section 1, sub H of ILUVA defines Land Suitability Rating System, LSRS, to mean, and I quote, Land Suitability Rating System means the system for evaluating land suitability based on soil, landscape, and climate factors as described in Land Suitability Rating System for agricultural crops, spring seeded small grains, published by Agriculture and Agri-Food Canada in 1995 and amended from time to time. End of quote. You will note that this definition of LSRS rating requires using the rating established by the Department of Agriculture and Agri-Food Canada and not a rating or reclassification established by Montrose through their soil survey and revalidation exercise that are still full of unknowns. The BHLG submits that the word any must be read in the context in which it appears in paragraph 4 of the IIR. The terms, and I quote, any LSRS class 1 or 2 land reported within the project footprint, end of quote, suggests that if one or some class 1 or class 2 lands are reported based on the LSRS rating system in the footprint, an AIA is required. The words any, reported, and within complement each other. Interpreting the word any in paragraph 4 of the IIR using the ordinary meaning of the word in the context within which it appears is appropriate and results in the conclusion that the evidence of the presence of class 1 of a LSRS class 1 land within the footprint of a project requires an AIA to be completed and submitted with the application. The requirement in section 4.1 of ILUVA and paragraph 4 of IIR is that the AIA must be submitted with the application for the power plant approval. Not meeting this requirement means that Grand Solar's application is incomplete and Grand Solar must be sent back to the drawing board through a denial of this application. While section 23.1 of the AUC Act gives the Commission the discretion to make any orders it deems fit, the BHLG submits that the Commission's order cannot contravene the provisions of ILUVA. If it was the intent of the legislature at the time ILUVA was passed that the Commission can permit the submission of an AIA as part of an approval condition, the legislature would have specified this intent in the wording of section 4 of ILUVA. And this addresses the alternate disposition that my friends had submitted to you this morning. The BHLG submits that there is no provision in ILUVA to indicate the legislature's intent that the Commission can require an AIA as a condition of approval or after a hearing has been completed. Grand Solar took a risk in submitting this application without complying with the IIR, which is backed by ILUVA. Therefore, it must bear the consequences of that risk, which is a denial of this application. Grand Solar argues that it is allowed by the July 2025 guidelines filed as Exhibit 111 to conduct a field assessment to validate the primary LSRS classification of each quarter section. The BHLG submits that the 2025 guidelines does not apply to Grand Solar's application, given that it was filed in May 2020, given that the application was filed in May 2025, prior to the issuance of the guidelines in July 2025. Even if the July 2025 guidelines did apply, Montrose still found Class 2 soils in the project area after their soil survey. The Commission's Bulletin 2025-12 at PDF page 2 clearly indicates that the Commission would develop interim information requirements to deal with the guidelines, and that those interim information requirements will apply to applications filed on or after August 26, 2025. This is a clear indication that the guidelines, the July 2025 guidelines, only applies to applications filed after August 26, 2025, which in this case, this application was filed in May 2025. The BHLG notes that the IIR was developed by the Commission as requirements for new power plants filed on or after December 6, 2024. The ILUVA was proclaimed into force by order in council issued on December 6, 2024. The IIR was intended to give effect to the requirements of Section 4.1, 1F, and 1H of ILUVA. As far as Grand Solar's application is concerned, the BHLG submits that the applicable regulations are the ILUVA and the IIR issued by the Commission pursuant to ILUVA and its authority, and the Commission's authority to make rules. The BHLG submits that the guidelines Exhibit 111 do not apply retroactively to Grand Solar's application. If the Commission decides to consider the provisions of the guidelines in accepting the soil survey work done by Montrose, the BHLG submits that the Commission must consider all of the applicable provisions of Exhibit 111, as well as the completeness of the field survey work in determining whether to validate Montrose work. In any event, and despite the gaps and the lack of full compliance with the SIL 2 standards, there are Class 2 lands reported within the project lands as Dr. Whitson had described at page 255, lines 4 to 14 of the transcripts. And basically, that there are classes 2, 3, 4, and 5 lands within the project footprint. A distribution of class 2 to 5 soils is consistent with Agrasys reported distribution of LSRS classes as provided by Grand Solar in Exhibit 97, PDF 95. Going now to the next sub-issue. Are the project lands high quality agricultural lands based on its productivity? Or conversely, if the project lands are not high quality agricultural lands, can the Commission exercise its discretion to order an agricultural impacts assessment? The BHLG submits that the project lands should be assessed as highly productive agricultural lands. The expert evidence of Ms. Nolan and Dr. Whitson, the multiple years of yield data from AFSC comprising yields from multiple farmers in the same growing conditions, as well as individual yield information from the BHLG members, and the oral testimonies of the BHLG members who own and farm adjacent farmlands support this submission. As explained by Ms. Nolan at page 257 of the transcript, the 2 years of yield information from one farmer, Clifford Wold, is limited, lacks details about specific inputs of management, including seed density, fertilizer use, and whether or not soil testing was conducted, and does not provide convincing and credible support for any contention that the project lands are not highly productive agricultural land. Mr. Wayne Thomas, in his testimony yesterday at pages 285 to 286 of the transcript, also commented on the gaps in the yield information presented by Grand Solar and the fact that the yield information was not sought from the current land tenant that is operating the farm, Mr. Mike Crouch of Crouch Farms, who farms the majority of the project lands. Again, you have incomplete and unreliable data that Grand Solar seeks to have you uphold as being representative of the production of the project lands. The BHLG submits that such claims by Grand Solar should be rejected. Further, 2 years of limited data from Clifford Wold, who farms a small portion of the project lands, does not and should not outweigh the evidence from 5 years of yield data from AFSC for risk area 12, which confirm that lands in the project area are highly productive, and consequently the project lands are highly productive agricultural lands. During questions by the Commission, Henry Thomas, Dara Thomas, and Mr. Wayne Thomas testified that their lands adjacent to the project lands were assessed by Flagstaff County as predominantly Class 2 lands, and produced significant yields consistent with the yields in Risk Area 12. I refer to transcript pages 316 to 318. As Ms. Nolan explains at page 258 of the transcript, Agricultural Financial Services Corporation, or AFSC, as AFSC's risk areas are representative of yields in the project area, as it groups yields within areas of similar growing conditions, and it represents yields for multiple farmers for a particular growing season and for a particular year. This is evident when Exhibit 104 to 108 are reviewed. It is unknown why the limited yield data presented by Grant Solar is low in comparison to adjacent lands. The BHLG submits that without any explanation or supporting data for the low yield reported in Exhibit 133 PDF 13, the yield information should be rejected by the Commission as unreliable. The BHLG notes that AFSC's Risk Area 12 yields are consistent with yields from BHLG members who farm adjacent quarters to the project lands. The BHLG notes that the Commission in Westlock Decision 28587-D01-2024 described the policy rationale behind the Agriculture First policy and Minister Nudov's February 28, 2024 letter as being a conservationist approach to lands with high quality, to lands with high agricultural suitability and productive value. At paragraph 13 of that decision, Chiadoriz says, and I quote, "In this case, the Commission understands the Minister's policy advice to be advancing a conservationist approach to lands with high agricultural suitability and productive value. As such, when evaluating whether the project is in the public interest, as mandated by Section 17 of the Alberta Utilities Commission Act, the Commission has considered a general conservationist approach to one of Alberta's resources that is potentially affected in this case, namely highly productive agricultural lands, as part of its assessment of the project's social, economic, and environmental effects," end of quote. The adjacent landowner in the Westlock decision, Mr. Brown, provided yield information for various years across various crops to support the productive value of the West Solar project lands. Note, Mr. Brown did not farm the project lands, but he provided yields from his own lands that are adjacent to the Westlock solar projects. Chair Doris, who decided, Chair Doris, who decided the case, accepted the evidence of the high yields from Mr. Brown's adjacent lands and said at paragraphs 21 and 22, and I quote, "Meanwhile, N. Brown submitted that not only does this type of project take highly productive land out of agricultural production, but it also has potential impacts to the rest of the community. The project is proposed in a community that is largely rural and agricultural in its land base. This means that businesses in Westlock, which serve the agricultural community, thereby creating employment opportunities and tax revenues, may be negatively impacted by this reduction in highly productive land in the market. In addition, as the supply of highly productive lands is reduced, farmers looking to expand their operations will have to pay a higher price for highly productive land." And at paragraph 22, Chair Doris continues, "N. Brown also submitted evidence that demonstrates the land in this area is notably productive and typically exceeds local and provincial averages for crop production. In the Commission's view, these lands are highly suited to agricultural use and have a greater than average ability to sustain agriculture compared to more marginal classes of agricultural land. The Commission finds that removing these highly suitable lands from agricultural production or diminishing their agricultural potential would be detrimental to the community and to Alberta. And at paragraph 23, Chair Doris continues to say, the sum of these social impacts are concerning for the Commission, and because of these concerns, it is difficult to accept without concrete evidence assertions that the community benefits will be positive. Overall, the Commission is not prepared to find that this project siting is beneficial when reviewing its impacts on the social aspects of Alberta's public interests. On this point, the Commission agrees with N. Brown's submission that there are likely other locations within Westlaw County where the benefits of solar production may be realized on lands which have less agricultural value. End of quote. The evidence presented before you by the BHLG in the joint report filed by Dr. Whitson and Ms. Nolan and the oral testimonies of the BHL members is similar to the evidence presented by N. Brown. The BHLG submits that a similar finding and a denial of this project is warranted. In the unlikely event that the Commission decides that Grand Solar's evidence is compelling, such that the project lands are not highly productive or high-quality agricultural lands, or that it is in the public interest to approve this application pursuant to Section 17(1) of the AUC Act, the BHLG submits that the Commission should require an agricultural impact assessment that meets the requirements of the Guidelines Exhibit 111 to be completed and filed by Grand Solar. Should the Commission decide to follow this approach, the BHLG requests that they be allowed to participate in any process established by the Commission to consider the adequacy of the AIA. This approach ensures that the BHLG can voice their concerns and are not prejudiced by any decision involving the AIA. This alternative approach is supported by the July 2025 Guidelines Exhibit 111, which states in Section 200.1.14, and I quote, for LSRS Class 3 land, if it is not defined as high quality, if it's not already defined as high quality agricultural land in Section 1F2 II of ILUVA, avoidance or coexistence is nonetheless encouraged. Now I will just respond to a few comments from my friend this morning before I go on to the next sub-issue in relation to municipal planning documents. So regarding some comments from Ms. Oliniak this morning on the Commission's power to order an AIA, we provide the following comments. We submit that the Commission has power to interpret the ILUVA as it is a regulatory body with authority to approve this project if it is found to be in the public interest. The Commission has exercised its powers through the IIR that it issued. BHLG submits that this exercise of power is valid and should be upheld by upholding and applying the provisions of the IIR to Grand Solar's application. If the legislature conferred the Commission with the necessary statutory power to require a proponent to submit an AIA, asking the Commission not to exercise this statutory authority in a deserving case such as the current case is tantamount to asking the Commission not to carry out its statutory duty. And we disagree with Ms. Oliniak's view on this. We also do not agree that Grand Solar's position that the government of Alberta's agriculture first policy and the ILUVA only requires an AIA in a situation where the project lands are just class 1 or class 2. That's a restrictive view of Minister Nathan Nudoff's February 28, 2024 letter to the AUC. In doing so, the Commission can and should utilize all its statutory powers in taking the agriculture first approach, which includes requiring an applicant to submit an AIA, notwithstanding that the project is not located on Class 1 or Class 2 lands. Minister Nudoff's letter did not state that the Commission cannot or should not request an AIA if a project is not located within Class 3 lands that are within the if the project is not located on Class 3 lands covered by Schedule 1. Minister Newdorf's letter and ILUVA only directs when an AIA is mandatory without restricting the ability or the discretion of the Commission to request an AIA in deserving cases in furtherance of the Agriculture First policy. Now, going on to the sub-issue of, is the siting of this project on highly productive agricultural lands compliant with municipal planning documents? The BHLG submits that the siting of this project on highly productive agricultural lands is not compliant with municipal planning documents. The Municipal Development Plan, or MDP's goals, as stated by Grant Solar in Exhibit 1, PDF 37, focus on supporting agriculture and promoting responsible energy development. In furtherance of the goals, the MDP stated at section 10.2.2, which was quoted in page 16 of the transcript, that, and I quote, industrial uses shall be encouraged to locate on lower capability agricultural land in proximity to paved county roads and in areas with access to existing water and three-phase power services where possible, end of quote. Section 10.2.3 also states that, and I quote, industrial uses shall be encouraged to locate in areas that are designed and serviced to accommodate industrial development, end of quote. The project is sited on high quality and high productive agricultural land in contravention of the MDP. The area where the project is sited is not an industrial area, but in an area designed for agriculture. Mr. De La Cruz's assertion at page 17 of the transcript that the wording of section 10.2.2 and 10.2.3 encourages compliance and that it is not prescriptive. The BHLG disagrees with Grant Solar's assertion. The use of the word shall in both cases denotes an intention by the county to compel compliance by not approving applications for development that are not properly cited in compliance with the MDP. Unfortunately, we don't have the county in this proceeding, but I just thought I should present that information too. Mr. De La Cruz's evidence at page 19 of the transcripts indicates that Grant Solar did not attempt to screen out high-quality agricultural lands as part of their site selection process. Having failed to screen out the high-quality agricultural lands in its site selection process, Grant Solar failed to demonstrate coexistence of the solar project with agricultural production, thereby failing to comply with the MDP and the IIR requirements. In the Foothills Solar Decision 27486-D01-2023, the Commission stated at paragraph 23 that it has consistently held that it must have regard for a municipality's land use authority and planning instruments when deciding if approval of a project is in the public interest. The Commission at paragraph 41 of the Sharp Hills Wind Farm Decision 22665-D01-2018 stated that the existence of regulatory standards and guidelines and a proponent's adherence to these standards are important elements in deciding whether potential adverse impacts are acceptable in deciding applications before it. The BHLG submits that Grant Solar has not complied with the MDP, the IIR, and ILUVA. The non-compliance warrants a denial of Grant Solar's application. The BHLG believes that there are other potential alternative sites available for the project that would be far better suited than what is currently applied for in this proceeding. The BHLG believes that marginal LSRS soil lands, which have severe limitations for food production, may be available in Flagstaff County and should have been selected for this type of power plant and energy storage project. Regarding the comments by Ms. Oleniak that productivity is irrelevant to the definition of high quality agricultural land, we disagree. Productivity is inherent in LSRS classes, hence the differentiation in classes, in soil classes. Ms. Survey agreed in cross that class 2 lands are more productive than class 3 or class 4 lands. With respect, Ms. Oleniak's submission is not consistent with the evidence of Grand Solar's expert, Ms. Survey. Now, going on to other agricultural impacts of the project on adjacent farmers and lack of mitigation. I can stop, Vice Chair Lada, if you want me, otherwise I'll continue to address the others. If you have questions.
I have one question regarding your legal arguments, and yeah, I will ask it at this time then.
Okay, sure.
As a general principle in the hierarchy of legislation, can a commission rule contradict, alter, or otherwise amend a regulation?
No, I would suggest no, that the commission rule cannot amend the regulation because the regulation is passed by the legislature and there are processes followed before that is passed and proclaimed. And if there is if it is required that the regulation has to be amended, then it has to go through the normal legislative process of amendment.
In our interim rule, we see the word any. We don't see it in the regulation. Is that in keeping with the general hierarchy of legislation?
I would say that that is still in keeping with the power of the commission to interpret the regulation to suit its public interest determination that it has to make. The purpose of, in my argument earlier, I had referred to the general powers of the commission to make rules regarding how applications will be decided, including the processes and the requirements. So the IRR is made pursuant to that power, and a regulatory body like the AUC has powers to interpret a regulation to suit the purpose that it's required to execute. And in doing that, what it has done is put in the word any to make it clear as to what the expectation is in regards to what it will be looking at when it's making its public interest determination.
So you're asking us to effectively read in the word any in the regulation.
That's my understanding. And I think it's still consistent with the regulation. And if you look at it from the perspective that the principle of conservation that is endorsed in Minister Newdorf's letter, which of course translated into the ILUVA that was proclaimed, that principle still carries through to the ILUVA. So even if you're reading the word any into that interpretation, it's still consistent with the conservationist approach and the principle.
Thank you. Please proceed.
Okay, thank you. Agricultural impacts of the proposed project on adjacent farmers and lack of mitigation. Related to the issue of the proposed siting of the project on productive agricultural land and the reclassification of the project lands is the agricultural impacts of the proposed project on adjacent farmers. During their testimony yesterday, Wayne and Shona Lee Thomas explained that they raised concerns about weed, pest control, and impacts to their farming operation during the consultation process. However, Grand Solar failed to address these concerns. The BHLG submits that Grand Solar is taking a reactive approach to these serious agricultural issues, which is capable of imposing increased farming costs and risks on adjacent farmers. This should not be the case. Other than Grand Solar's commitment that it will develop plans, Grand Solar has not taken any concrete step to address these very real farming concerns that are capable of causing severe economic damage to the farming operations of the BHLG members. The BHLG submits that if Grand Solar was being duly diligent in its project planning, Grand Solar should have known that weeds, Richardson ground squirrels, and crop pest insects are concerns for adjacent farmers, and therefore should have proactively developed and provided its rodent and insect pest management plans aimed at mitigating those concerns. With respect, the BHLG submits that Grand Solar's commitment to develop plans at a later date to address weeds, Richardson ground squirrel, and crop insect pests are not sufficient given the very real farming risks that siting the project at the proposed location poses to the farming operations of the BHLG members. As you heard from Wayne and Shona Lee Thomas, a fenced, non-actively farmed site is a breeding ground for pesticide-resistant kochia and Richardson ground squirrels. And if a prevention plan does not work, then landowners will have an ongoing management challenge for decades for a project they did not ask for. Reiterating this point, Mr. Darrell Thomas noted during his testimony yesterday that it is very hard to mitigate when a land is overrun by Richardson's ground squirrel. During cross, Montrose noted that they would recommend the use of poison and chemicals as control methods for Richardson ground squirrel in the proposed plan to be developed. However, as explained by BHLG members that have first-hand experience with dealing with Richardson ground squirrel, the available poisons are not effective and trapping would not work, which begs the question, how will Grand Solar effectively control the spread of Richardson's ground squirrel from the uncultivated project lands to adjacent landowners? Grand Solar has not suggested or proposed any viable, effective mitigation measures in this regard. You also heard from the landowners yesterday mentioned the most effective way that they have seen and used to control ground squirrel is to shoot them. Of course, that's not an option. So, and chemical control also, we heard also, can also impact the food chain and domestic animals such as the pets of adjacent landowners. So the option really, based on what Grand Solar's expert was saying, is to trap them, but there is no evidence before you about the efficacy of that method. So we still maintain that this issue still remains unresolved and no effective mitigation has been proposed. Okay, so by not developing and presenting the proposed plans for the control of Richardson's ground squirrel, crop insect pest, and pesticide-resistant kochia, this BHLG submits that the landowners and the commission are denied the opportunity to review and question Grand Solar on the content and effectiveness of its plans as part of the regulatory approval process. The BHLG submits that the Commission cannot properly and fully evaluate the agricultural impacts of the proposed project without considering how Grand Solar will effectively mitigate or eliminate the concerns regarding the spread of weeds, Richardson's ground squirrel, and or crop insect pests from the project lands to the adjacent farmlands. In the absence of those concrete tested plans, the BHLG submits that it is not in the public interest to accept unmitigated agricultural impacts of the proposed project. For the BHLG, the only option is for the Commission to send Grand Solar back to the drawing board through a denial of this application. Going now to air dispersion modeling, fire risk mitigation, evacuation zone in the event of a burst fire, and emergency response. The issue of fire risk, air quality, and hazard assessment, fire risk mitigation, and evacuation zone in the event of a burst and or solar fire are issues that members of BHLG have expressed strong concerns about. While the risk of fire at the BESS facility may be low due to safety features in the lithium-ion BESS equipment proposed for this project. There is still evidence of recent fire occurrences at BESS sites with similar technology. I refer the Commission to Exhibit 112 PDF 86 to 99 and Exhibit 116. Aside from BESS fires, Exhibit 113 indicates fires occur at solar sites, and those fires are underreported. You heard members of the BHLG speak about their greatest fear of being unable to escape in the event of fire occurring at the project site. Intermode, in its air dispersion modeling, modeled a reasonable worst-case scenario in the event of a BESS fire using a Larsen et al. Emission factor and arrived at a calculated evacuation zone of 615 meters. This distance is the maximum distance where concentrations could exceed health criteria. Intermode's calculation of a reasonable worst-case scenario is supported by EPRI 2024 white paper that was filed as Exhibit 68. At paragraph 9, at PDF 9, paragraph 3 of Exhibit 68, EPRI states that first responders may be more interested in the maximum distance away from the site at which concentrations can exceed health criteria than the exact concentration maps. This is what Intermode has done in this instance. Intermode has provided you with the maximum distance where concentrations of toxic gases can be hazardous. Clearly, EPRI recognizes the importance of modeling the maximum distance that concentrations may exceed health criteria, which is equivalent to modeling a reasonable worst-case scenario. EPRI goes further to state that the maximum distance is easier to communicate, to use for decision making, and to enforce for any evacuation and shelter-in-place orders implemented by the fire service managing the response. EPRI statement is consistent with statement by Rick Saulnier of concerned with the statement of Rick Saulnier, an emergency first responder in Foothills County, that a worst-case modeling should not be dismissed, as such dismissal would contradict Alberta's Emergency Plan 2022. Apparently, a worst-case scenario modeling is useful to emergency responders and should be accepted and considered by the Commission. RWDI modeling, on the other hand, used an emission factor of 17.2 grams per kilowatt hours to predict a maximum distance of 163 meters. RWDI claims that its emission factor is conservative because it is consistent with the average range of values presented in RAPSILBA 2025. A review of RWDI's undertaking response filed in relation to RAPSILBA 2025 emission values shows a maximum emission factor of 59.9 grams per kilowatt hours being reported for prismatic LFP batteries, which is similar to the LFP batteries proposed for this project. 59.9 grams per kilowatt hours is more than 3 times the 17.2 grams per kilowatt hours that RWDI used in its modeling. This demonstrates that RWDI's modeling is extremely conservative. Grand Solar and its experts are of the view that Intermode's modeling represents a risk scenario that is unlikely to occur, because the modeling results are not supported by real-time measurements of air emissions after the Moss Landing fire in California. There are issues with Grand Solar's views. First, neither RWDI nor ESRG presented the results of the air quality measurements in the Moss Landing BESS fire to allow for independent assessment. Second, the measurements of the Moss Landing fire did not commence at the time the fire commenced. This was confirmed by Mr. Petrakis at page 88 of the transcripts and at PDF, excuse me. And at PDF page 4 of Exhibit 126. As noted by EPRI in Exhibit 68 PDF 9, the highest total gas release rate occurs at the pre-combustion or off-gassing phase, and the combustion phase removes a large amount of the gases released. So By the time EPA and CTEC came to commence air quality measurements at the Moss Landing site, which is 16 hours after the start of the fire, the amount of HF and other toxic gases released is significantly reduced. It is interesting that Mr. Petrakis could not say at page 90 of the transcript when the toxic emissions are highest, despite claiming that ESRG has completed 350 UL 9540A tests, and during those tests had completed monitoring with handheld meters, see Exhibit 7 of PDF 7 of Exhibit 127. Third, contrary to Mr. Petrakis' undertaking response number 2, there is no report of any measurements completed by Vistra, the owner of Moss Landing Base facility. Exhibit 126 PDF 4 references only measurements by EPA, and CTE, an independent monitoring firm engaged by Vistra. And lastly, the battery type in Moss Landing fire is different from the lithium-ion battery proposed for this facility. The BHLG submits that the air quality measurements from Moss Landing fire are unreliable and cannot be used to rule out risk of exposure to harmful toxic gases in the event of fire at the project site. While Grand Solar takes issue with Intermo's modeling of a reasonable worst-case scenario, the BHLG knows that RWDI does not dispute that modeling of a worst-case scenario is appropriate. Mr. Dawson was questioned about this at transcript page 54 to 55, but he was evasive in his response, choosing instead to say that he modeled an alternate release scenario. Similarly, Mr. Petrakis at page 178 of the transcript endorsed the test done by BYD, the manufacturer of the proposed equipment, as representing a, I quote, very, very worst case scenario, end of quote. Intermode used the BYD test in determining their fire scale factor of 20% of the units burning in their air dispersion modeling. Note that RWDI refused to accept that 20% of the racks in the unit burnt despite clear evidence of this. There is obviously a disconnect between ESRG and RWDI's evidence in this regard. In relation to evacuation zone, Intermode did not recommend a default evacuation zone. That's Exhibit 112 PDF 62. What they have presented is a maximum distance that can guide emergency responders in establishing an evacuation zone. This approach is consistent with EPRI recommendation to provide information to assist emergency responders in managing an incident and managing a fire incident and in communicating actions. I would also note that in the numerous fire incidents that have occurred this year, that despite modeling reports that indicated some distance, maximum exposure distance, that the actual evacuation zones were much larger than what was modeled. So that's also consistent with what Intermode has done in this case. Mr. Petrakis says he does not believe in establishing an evacuation zone. Instead, ESRG's practice is to recommend a 100 feet or 30 meter staging area from the burning BES equipment for fire responders to stay and manage the incident. This recommended 100 feet staging area is even smaller than the recommended 330 feet distance that EV manufacturers recommend in case of a fire involving an electric vehicle. Regardless of whether 100 feet distance is appropriate, it is important that the Commission note that the 100 feet distance is for emergency response personnel. It does not tell the emergency response personnel what to do in the event a fire occurs that may require evacuation of residents and livestock. In fact, Mr. Petrakis and Mr. De La Cruz were questioned about what the plan is for evacuation in the case it is needed. Mr. De La Cruz says it will be detailed in ERP. Mr. Petrakis says that the emergency responders are sufficiently trained to know what to do. Well, that is not a plan, and neither does it reassure the BHLG members that Grand Solar knows what to do or that adequate measures will be in place to protect them, their livestock, and residences. The BHLG landowners the BHLG landowners panel proposed mitigation measures that could be adopted to ensure their safety. The BHLG requests that the Commission should adopt the mitigation measures that the BHLG members propose at pages 311 to 314 of the transcript should it decide to approve the project. In addition to adopting the recommendations by Intermode at Exhibit 112 PDF 13 to 14 as conditions of any approval. Going now to the issue of water availability for fire response. The issue of
Ms. Sequoia, if I could interrupt you just for a moment.
Yes, sir.
Can you give me an estimate of how much more time you require?
15 minutes or less.
Please proceed.
Okay. The issue of availability of water for fire response continues to be of concern to members of BHLG. While ESRG claims that water is not needed to fight best fires, ESRG noted that water will be needed to cool adjacent exposures, which includes adjacent battery units and vegetation. This means that there has to be on-site water source for fire responders or Grand Solar's personnel to use to manage the fire pending the arrival of fire responders, which in the project area could take from 45 minutes to an hour or more. The need for water is further underscored by the Boulder City Fire Responders Management of the September 23, 2025 Best Fire Incident in Nevada. According to Fire Chief Morgan, and I quote, "The fact that there was a good water supply, our fire prevention division made sure that there was good hydrants out there. Anticipating something like this, the water supply was there, which was one of the biggest factors we had, end of quote. At the project site, there is no on-site water supply. It is not manned 24/7. The nearest fire service department is located 45 minutes to more than 60 minutes away. There is no defined plan as to how to keep the fire from spreading to adjacent vegetation or the adjacent solar facilities or neighboring landowners' lands, pending the arrival of fire service. There is no evidence that a nearby water source is available in the event that fire service needs additional water. Most of the nearby residents have only one entry and exit access to their properties. In the views of the BHLG, the fire risk has not been sufficiently mitigated, and this warrants a denial of the project. In relation to noise impacts, we say that the NIA completed by RWDI is flawed, unreliable, and should be rejected. There were numerous errors and lack of compliance with the applicable ISO standard that make reliance on the manufacturer's test results untenable. These errors and issues were raised by Mr. Dehan in his confidential memo and were confirmed by Ms. Drew during cross and in her reply evidence. The BHLG submits that RWDI's use of manufacturers' test data in completing the NIA resulted in a flawed and unreliable NIA. In addition to the flaws, the overall ground factor of 0.8 is higher than the range of ground factor of 0.5 to 0.7, typically used in other solar projects, including in the Stettler solar project that has similar topography as the proposed project location. We note that Grand Solar has committed to completing the NIA, and the BHLG requests that the recommendations contained in Mr. Dehan's report at PDF pages 4 to 5 of Exhibit 113, and as we are further explained by Mr. Dehan at pages 259 to 264 of the transcript, should be considered for inclusion as conditions of approval should this be approved. In relation to the use of driven piles, as recommended by Mr. Dehan at page 264 to 265 of the transcripts, pile driving activity should not be permitted to occur during the nighttime period. We've heard today that that will not occur, so that is good to hear. In addition to that, Mr. Dehan also recommended that pile driving should be limited to not more than 5 days a week during the daytime hours, and we ask that the commission consider that as well. In relation to surface hydrology and groundwater impacts, erosion, the BHLG submits that Grand Solars has not put in place adequate plans as it relates to the potential impacts of the project on surface hydrology and groundwater. And as explained by Dr. Whitson in his evidence yesterday, issues relating to water balance concerns such as infiltration, soil moisture, plant growth, and erosion should have been explored during the environmental evaluation for the operations phase of the project, but they were not. The BHLG submits that Grand Solar's failure to consider these issues in the EE shows a lack of preparation on their part. Relying on future development of plans for the management and mitigation of key environmental issues should and ought to have been fully considered and addressed. This didn't happen, and this warrants a denial of the project. In relation to glare, we note that Grand Solar has committed to using a resting angle of 5 degrees, and we submit that that should be required if this project is approved. Project benefits. Grand Solar makes vague statements about project benefits that will arise from this project. The 99,000 homes that Grand Solar asserts that this project will provide electricity for is not proven. Ms. Olniak's assertion today that the project benefits are significant is simply not supported by the evidence. Even the jobs that they said they will give, there is no information backing that up to support that those jobs will be sourced locally. So in conclusion, there are many gaps in Grand Solar's application that warrant a denial of this project. And as stated earlier, the BHLG submits that the project as applied for is not in the public interest. When assessed, I guess the adverse impacts that will be created, including but not limited to those raised in this argument. And as such, this project should be denied. Thank you.
Thank you, Ms. Okoye. Ms. Higgins, do you have any questions on the argument? No? Ms. Oleniak, we scheduled a half hour for your reply argument. Can you give us an estimate of whether you're going to take a half hour or something less?
Certainly. Sir, I don't anticipate we have any reply argument to deliver other than responding to the question that you asked this morning, which I undertook to address. And I just, in discussions we've been having here and thinking about it a bit more, I understood your question was what percentage of Class 2 land would qualify as high quality agricultural land and thus trigger the regulation. And you noted Dr. Whitson's undertaking response that his view is it's the Class 2 soil in the project area is 10 to 15%. I'm not aware of anything in the regulation, government policy, or on the record that I could direct the commission to on this point to respond to it. And it's likely the response to this will be provided by Ms. Sauvé. And for that reason is probably more correctly characterized as evidence as opposed to argument. So my suggestion to the commission was going to be that we file a brief response on the record this afternoon from Ms. Sauvé that essentially responds to your question and to Dr. Whitson's undertaking, if that's acceptable.
Yes, that's fine. I'll ask our counsel, are there any matters that we need to deal with before we close the hearing?
No, Mr. Chair.
From the intervener's side, anything? Oh, you're muted.
Sorry, nothing, sir. Thank you.
All right. Well, I want to thank everyone who participated in the hearing, the applicant, company representative, the expert witnesses on both sides, the landowners, our commission staff, and my co-panelist, Ms. Higgins. It's been an instructive hearing, and we appreciate everyone's effort in helping us come to a decision. With that, we're closing the hearing. Thanks, everyone.
Thank you, sir.
Thank you.